sure if the secretary will help introducing the background of the speakers, or I should do that. Ms. Han.
Yes, so I'd like to have some minutes to have some opening words for our webinar. Good afternoon, ladies and gentlemen, dear friends of arbitration and mediation. I'm pleased to welcome you all to the webinar of the Vietnam International Arbitration Center and the Vietnam Mediation Center on the combination of mediation and arbitration, discussion of the new tendencies and its adoption in Vietnam. This is a part of our series focusing on ADR and in practice in Vietnam, and the series is aimed to provide the notable trends and key development of the ADR in the post-COVID-19 world. The globalization and the complex commercial transactions had demand more efficient and faster dispute resolution, and this has led to the innovation of the combining mediation and arbitration. So it is believed that the combination has offered parties in dispute a lot of benefits, but at the same time, a lot of implied risks to be noticed by the experts. So therefore, VIAC is hosting this webinar to provide essential information, drawing from the knowledge and experience of our distinguished speakers and aimed at helping the parties to make the better choices when deciding on ADR. I'd like to introduce our panel today. First, we have Mr. Nguyễn Trung Nam as our keynote speaker today. Mr. Nam is our Deputy Director of Vietnam Mediation Center, a division of the Vietnam International Arbitration Center. He's also a very famous expert in international arbitration and a member of our Silent Council at Vietnam International Arbitration Center. At the same time, of course, he is a founding partner of the EP League. And in the panel discussion session, we will have Mr. Christopher Wing To, the VMC listed mediator and the counsel of the Guild Chambers from Singapore, connected with us today. And we have
Hong Kong.
Mediator listed in our list of mediator and the partner at Nishimura and Nashahim in Vietnam. We have also
in Tokyo.
We also have
I'm based in Tokyo. We have offices in Vietnam.
Partner of Zumenso Associate, who is a very talented young practitioner in arbitration and also in litigation in Vietnam. He is the ambassador of the IBA in Vietnam. He is the very famous representative of the young ADR group in Vietnam. That is our pleasure to have you all distinguished speakers to be here with us today. So I am confident that this webinar will bring to the audience a lot of exciting information about the combination of ADR tendency, and also offer valuable insights and practical notes from the experienced legal practitioner. So without further ado, I'd like to give all the audience our keynote speaker, Mr. Nguyễn Trung Nam. Thank you.
Thank you, Ms. Hằng. I think we are a little bit unprepared because it's not yet time. We thought that we had some minutes for us to discuss internally how we move forward. But anyway, let's start because it's now almost time now. We are talking today about a quite new concept in Vietnam, which is variant mediation and arbitration combination. And I understand that it has been in practice in Vietnam for quite a while, but it has not been very much talked within public domain, and also within the scholarly talks on the combination of mediation and arbitration. So first of all, I will try to give a very quick brief of what it is, what are the practice in different parts of the world, and later I will give the floor to the speakers to talk about this. Before I start, I will share the screen with the slides so that my speak will be able to be seen. Yeah, I hope you are looking at it now. So I will talk about MET-UP and UP-MET, the two variants, and finally the UP-MET-UP. What are they and how they are done in general? The MET-UP has been introduced quite a long time ago. It's actually the combination of mediation, in short MET, and arbitration, in short UP. And there has been a question of whether this combination will result in a more successful settlement dispute resolution mechanism, or it is just another IDR method that has its own limitation, and we will discuss it later. But I understand that in Japan, for example, there was regulations to allow a mediator to be an arbitrator as well. For example, an arbitrator is allowed to attempt to settle the dispute if the parties consent. Similarly, in Vietnam, we have Article 9 of the Commercial Arbitration Law, which allows the parties to request the tribunal to mediate the disputes. And sometimes the tribunal itself may inform the parties, at least in my practice, and I believe that there are other arbitrators in VIAC also do the same. They are allowed to tell the parties that you have the right to request us as an arbitrator tribunal to do mediation and to conduct the mediation for the parties' settlement. But before we go into all these details, we need to distinguish these two methods of dispute resolution. And most of the time, the arbitrators, if they don't have the background of mediation, they may confuse the different types of mediation, and that's why they may think mediation is just as another version of arbitration. Mediation has two main approaches. The first approach is facilitative mediation, which is very preferred by the Western mediation communities right now. And in facilitative mediation, what the parties usually expect is that the mediator set out the commercial environment and aspect for the parties to look into the future and look into the core interests of each parties, especially the commonalities, and to try to avoid the to elaborate the difficulties. So the mediator in this facilitative approach is only facilitating the environment for the parties to get closer and to try to settle the disputes. And they are not giving the opinion, or they do not give any suggestion or proposal of the parties' legal stand or the merits of each party, and they will avoid it by all costs to make sure that the mediator has the neutral position and to facilitate and encourage the parties to speak. The other approach of mediation is the very traditional evaluative mediation. And in this approach, the mediator will try to tell the parties their evaluative position of law, so they will know their strength and their weakness. And then the mediator may suggest some solutions that the parties may consider. So the second approach of mediation is a little bit similar to what an arbitrator as a neutral will do, except that the arbitrator will have the sole discretion to deliberate and to decide on the case, and the mediator will not. In reality, the map of the type of evaluative mediation has been done in quite a number of practical cases in courts and in arbitration. And it has been particularly successful in Vietnam, for example. People said it's better for the parties to know their strength and their weakness when they deal with the situation, and especially when they know that the mediator later will become an arbitrator solving the disputes. Then it will be better for the parties to learn that if they don't settle, what will happen to them. So in a reality test context. But on the other hand, there might be some disadvantages of this, as we will see later on. But currently, I would like to highlight some variants of MedApp which has been developed in the last few decades. Firstly, the pure MedApp, which means mediation and arbitration in a pure relationship. One person will play the role of both the arbitrator and the mediator. So that the pure original MedApp situation. And the main concern with this model is really the criticism by the Western mediator world, where they support the facilitative mediation, that the parties will be less likely to disclose the information for the resolution, and they are more likely to present the extreme arguments during the mediation, because they know that the arbitrator will also do the mediator will also play the role of arbitrator. The second variant is MedApp diff. And in this MedApp diff is a difference. The mediator and the arbitrator will be two different people. And this will solve the problem that the MedApp pure was criticized. But the problem with this is that it will take more time for the arbitrator to learn the case. And it will consume the main value of the MedApp in the original case. And also there are different variants like MedApp diff and recommendation, and the co-MedApp that I'm not going to go into details, but we know that there are a lot of variants for MedApp in international dispute resolution. The advantages of MedUp is quite obvious. It has the advantage of the two worlds combined, mediation and arbitration. For mediation, it's ensure that the parties will have chance to decide what should not be resolved in arbitration. So it has the informed decision advantage. The parties make the decision by themselves, and it will cut down the time and cost for arbitration. Because it will very likely success if the parties try their best to negotiate in good faith and with the assistance of the mediator. And with regard to arbitration, it will ensure the outcome in any case. So if the mediation is not successful, then negotiation will end and the arbitration proceedings will come into play. And it will make sure that the final result will be enforced because the enforcement will be done over the arbitral award over the 160 member states of the New York Convention. And that is the main objective of the MedUp and the main advantage. The disadvantage of this MedUp is firstly the problem with the without prejudice, because the confidentiality is not always prevailing the other statutory obligation under certain civil jurisdictions. For example, in Vietnam, if the mediator is doing the mediation and then becoming the arbitrator or arbitration, then we do not know whether the parties' discussion during the mediation will be protected under the law. And you will need to disclose this information in the arbitration proceedings. Secondly, there has been a very big concern on the impartiality of the mediator who then become an arbitrator. And this case has been discussed a lot in Cao Hai Yen and Keynote Holdings case in 2011. I don't really have a lot of time to discuss in details, but this case, in this case, the Keynote Holdings tried to set aside an arbitral award resulted from a MedUp situation based on the fact that based on the fact of irregularity, and it raised the question of the impartiality of the arbitrator when he or she has done the mediation. And if a party does not cooperate in proceeding with the mediation before going to arbitration, what will happen? We have had a case, a recent case in Hetronics Corporation and the EPI Life Private Limited. And in this case, it involves a license agreement and distribution agreement, and the dispute resolution clause in the agreement provide that all disputes shall be submitted to the Singapore Mediation Center and the Singapore International Arbitration Center, the SIAC, for resolution by an MedUp in accordance with the SMC and SIAC MedUp procedure. The problem with this is that the plaintiff tried to invoke the dispute resolution clause by writing to the defendant to refer the matter to mediation pursuant to the MA clause, but the respondent tried to avoid that, and therefore the mediation could not take place. And what happened then? The plaintiff then decided to commence the proceedings in court rather than in arbitration. And the court proceedings commenced. The defendant then applied to stay the court proceeding on the basis that there was an arbitration agreement. So finally, the judgment dismissed the stay application, and as a result, in the electronic case, the case was proceeded in the court instead of arbitration. So if you want to have a proper arbitration clause, and you know that the other party may not cooperate in doing mediation, maybe you lose your opportunity to go to arbitration just because the clause operates in a way that the parties need to do mediation before going arbitration. So this may be another disadvantage. The other variant of the met and up combination is the arbitration and then mediation, which is not as popular as the met up. The up-met is the reverse order. Firstly, the arbitrator will do the arbitration. He or she will conduct the arbitration proceeding and will issue an award on a non-binding basis, and the award will be sealed. After that, he will proceed with the mediation. And if the mediation is successful, then the parties will just forget about the award. But if the mediation is not successful, then the arbitrator will open the seal and deliver the award to the parties. It has been seen in South Africa, in some auto and steel industry, and also in United States, mainly in the airlines industries. The problem with the up-met is that we don't see the time and cost saving here, because at the end of the day, you already done the arbitration and you have to spend a lot of cost and time on the arbitration. And finally, the up-met up, which has been taught a lot during the recent years. And in Vietnam, it has been introduced in the last couple of months by VIAC and VMC. We will have the opportunity to listen to Mr. Dat and Mr. Minh from Vietnam perspective on this. The up-met up is a process whereby a dispute is first referred to arbitration before the mediation is attempted. So you will have the arbitration started first, but then it will stay for a period, let's say 60 days, for the mediation to take place. And if the parties could settle their disputes through mediation, then the settlement may be recorded by the tribunal in the form of a consent award. And if the parties could not settle their disputes through mediation, then they just continue with the arbitration proceedings. In Singapore, for example, we have a very famous combined up-met up procedure preceded by SIAC and SIMC. Basically, it's the same as what I said. There are certain details, but I don't think that I should go into that details. In practice, the caseload between 2014 and 2018, 20% of the cases have been done on AMA, on up-met up basis. And as also between 2014 and 2018, 20% of the cases were related to non-Asian parties, and 80% relates to the Asian parties. So there's a tendency that the Asian parties prefer to use the mediation-related arbitration proceedings. In Hong Kong, there's also rules of the Hong Kong ISC arbitration, which allows the mediation or negotiation in the middle of the arbitration proceedings, which is Article 13.8 and 37.2a. And the VN, not the Vietnam, the VN International Arbitral Center also have the model clause, which allows the mediation to take place in the middle of the arbitration proceedings. And if it it results in settlement, then it will be an award on the agreed terms, or otherwise it will go through the arbitration proceedings. Now it's the end of my sharing, and I think the next part I will go into some details of this process by inviting the speakers, the panelists, to share their views and to share their practice in their own jurisdictions. The first question I would like to raise to the panelists is that what type of met-up variants, met-up or up-met-up variants are being used in your particular jurisdictions, and which one do you think is the most practical, efficient method for dispute settlement? And which one could make use of the advantage of arbitration and mediation? I would like to invite Mr. Tezuka Hiroki to start first.
Oh, thank you very much, and it's my pleasure to be a part of this panel on met-up. And my short answer to the question as to what types of met-up are used is it depends, and actually we use different types of hybrid arbitration mediation combination depending upon what the parties need. And for example, where the parties want to settle, but the settlement may involve some kind of installment or the obligation to be performed sometime later, then the simple outcome of the settlement through mediation may not be readily enforceable. So if you make the mediation proceedings converted into arbitration, where the mediator performs a function as a arbitrator, depending based upon the parties' agreement, then that is result. The result is a consent award, which may be enforceable. And as you know, now Singapore Mediation Convention has taken effect, and depending upon the jurisdictions, international mediation settlement may be enforceable, but still not many jurisdictions have signed the convention, so there are still need. And other types of typical situation is where the arbitrator wants to have some mediation in order to save time and cost. And sometimes the parties may want to have an entirely new, different person, but as you said, it is often the case that it takes time for the new mediator to run the case. And sometimes the parties really want the arbitrators to act as mediator. And if the mediation succeeds, that's fine. But if the doesn't succeed, the problem arises as to whether the mediator changes his or her hat again to arbitrator. And interestingly enough, the Japanese law, arbitration law, says that arbitrator may act as mediator only upon the mutual consent by the parties. But it is silent as to whether the mediator can turn to arbitrator. And the JCA rule says that it can, and the parties cannot raise the objection in terms of the impartiality if that is the original agreement. But still, you need to be cautious that, particularly for common law oriented players, such kind of mediator turning again to arbitrator is not something acceptable. So you really need to know who are the parties and what are their expectations. Okay, I will stop here.
Thank you very much. May I ask a little bit like a follow-up question on what you explained? From the user's perspective, do you think that they prefer in Japan, do they prefer the same arbitrator, the same person doing mediator and arbitrator, or do they prefer, or they have the tendency to request a different person to be the arbitrator?
I would say that most Japanese parties do not hesitate to have the same person to act as arbitrator and mediator, because in Japanese courts, there is an explicit provision which permits which allows the judge to act as mediator at any point of time during the proceedings, and the same judge can later make the judgment. Yeah. And I understand that in Germany, judges are fairly supportive in assisting the parties to discuss settlement. But I have learned from my German colleague that there will not be any ex parte discussion between judges and only one party. So that may be the big difference. And because of the Japanese court system, where judges can act as mediator at any time, I believe that Japanese parties have a little hesitation. But the point is, in international mediation, the other party may not share that tradition. That is the problem.
Yeah, I see. Yeah, it's very interesting. Thank you, Mr. Hiroki. I would now turn to Mr. Dat from VMC. I think we have learned some experience with Japanese and also German perspective. What do you think from Vietnam perspective? What is the practice now?
Thank you, Tony, and dear the panelists. Well, it's my pleasure to be back again to talk about ARP in Vietnam and at VIAC and VMC. Well, firstly, on legal ground, we do not see any provision on ARP. We do have legislation like the commercial law on arbitration, and also the decree on mediation separately. So at the VIAC, Vietnam International Arbitration Center, we have a VMC, Vietnam Mediation Center. According to the decree, an arbitration center can set up a mediation center, and that's the way VMC was born. So we have arbitration established since 1993, and mediation VMC only 2 years ago. So we think of a new product, which is the mixture of arbitration and mediation. And we just launched the protocol, ArmEd app. The purpose of the protocol, well, is to take advantage of both two dispute resolution methods. The first, well, it's not too strange. It's not abnormal. It's like in international standards. The first point, you know, statistics show that disputing party want to preserve and develop their business relationship after the dispute. So the hybrid dispute resolution, arbitration and mediation meets their demand. We expect that this is our new product will meet the demand of preserving the relationship. And the second point is efficiency and cost, in time and cost. We have here the diagram, or just show on the screen of the first circumstances. Technically, it has 9 steps, but we put it short in a diagram like this with 5 steps. Just remember that the claimant for the first to start the protocol, just for the first circumstance, the claimant, when they send the request for arbitration document, they put just put a sentence or put a request to invoke the ArmEd app protocol, and then the proceed runs. The circumstance difference from the first one only from the fact that the claimant does not request for ArmEd app at the first stage. And after arbitration starts, either one party, expectedly the respondent, will see the benefit of mediation, and then they request to VMC to start the ArmEd app protocol. Well, technically the procedure is like this. So the second step and the third, the fourth is for the two secretariat, the two procedure run dually. Bearing in mind that VMC belongs to VIAC, then the two secretariat work closely and so coherently with each other. So you see the 2 days informing period and the other 2-day informing period between the two secretariat to make sure that the process runs smoothly, efficiently, and fast. All other panelists has talked about the result of the process. You may have the MSA, which is the mediated settlement agreement, or in Vietnam, you have the decision by the tribunal, which is considered the validity as an arbitral award. And it depends on the disputing party whether they want to enforce it locally, domestically in Vietnam, or they may think of enforce it internationally under the regime of the New York Convention 1958. May I just put another benefit of the process, which is the cost. If you, the panelists, also the participants, have experience with VIAC arbitration, you will see that we have the cost schedule and also the refund schedule. So we have here the refund circumstances. Briefly, if you use the protocol, and we hope that it will result in the decision by the tribunal to recognize your mediation result, then we plan to refund you 30% of arbitration costs. Whereas if you take arbitration procedure alone, you may have a kind of settlement or consent award by the tribunal, then no refund at all. In detail, we will soon publish the full protocol on our website, both VIAC and VMC. But in short, we would like to conclude that we try our best to create a kind of protocol which meets your demand for both the efficiency and the enforcement possibility. Of course, it's quite technical and it takes time and maybe a little bit difficult to understand fully. But with the professional secretariat, we are sure that once you have a kind of dispute, before you send the request for arbitration, or right, even after you send the request for arbitration, but you, the claimant, or of course, from our side, the secretariat feel that or see that there's kind of possibility for mediation in order to keep your relationship and efficiency. We will recommend you, will assist you with the protocol, hoping that you will get a kind of MSA, mediated settlement agreement. Thank you.
Thank you very much, Mr. Dat, for very interesting and welcoming information from VIAC and VMC. We do hope that with this new mechanism in place, there will be more cases for us to talk about in the very near future. Now I would like to ask, following what Mr. Dat just explained, from Vietnamese Council's perspective, I would like to address this question to Mr. Minh. How do you think the audience, the users, will receive this concept, and how likely they would use this combination of MedApp or AppMedApp in Vietnam? Please turn on your mic, Mr. Minh.
Sorry.
Thank you.
Firstly, I would like to thank the VIAC and the VMC for this opportunity, and also for the very nice virtual background that we are using at the moment. And let's talk a little bit about what Mr. Dat just discussed. I think the idea about AppMedApp is actually very new in Vietnam, and even mediations and arbitrations, as we are discussing about today, are relatively new ideas in Vietnam. Mediations has been only like a couple of years old, and arbitrations under the LCA, the law on commerce arbitrations, is just around 10 year old. So today we are talking about very new concept, that is combinations in the form of AppMedApp. However, if you look at arbitrations in Vietnam in the past, you can see that the idea of combining mediations and arbitrations or negotiations has been there for quite some time. Like if you look at the ordinance on commerce arbitrations, the one prior to the law on commerce arbitrations, you will see Article 37. And in the law on commerce arbitrations, you will see Articles 9 and Article 58, and also in the VIAC rules. Basically, during the arbitration process, the tribunal can be requested to mediate a dispute if the parties really want so. And if the party can reach an agreement, then the tribunal will record it down in a minute, and then the tribunal will also issue a decisions to endorse the agreement between the parties. However, this is quite different from AppMedApp, as we just seen Mr. Dat explain in the protocol, because the way arbitrations and mediations has been conducted up to now is very much influenced by the way of mediations in the civil court, and it can be very evaluative. The tribunal can be very proactive in conducting the mediations, but there's no real separations between the mediations and the arbitrations, and that can create some complications or can create issues down the line. And also the mediations conducted under as a part of the arbitrations, as we see it in the LCA or the VIC rule at the moment. It's not really detailed. We do not have the set of rules like the VMC rules to govern the mediations. So that is the downside of the current model. And if we look at the protocol explained by Mr. Dat, and we can see that there's a separation, a degree of separations between the arbitration and the mediation proceedings. And the mediation proceedings is conducted under the VMC rules. So you do have a place to look to and to see how the process is going and to know what you should do in the mediations. I think that is my comment at the moment.
Thank you, Mr. Ming. As you mentioned, the two different approaches, the existing set up by the law and the arbitration rules, and also something new that VIC and VMC just explained by Mr. Dat. Do you think in your opinion, which one would be a better position in mediation, arbitration combined? The same person doing the mediation and arbitration as what is the current practice, or the one proposed by VMC and VIAC in their new protocol? And could you explain in the context of the Vietnamese business community's culture? Thank you.
I would say that it can be very much case by case. You will have to really see the situations to analyze which of the model is better suited for you. But as we already discussed up to now, the current model does have its advantages in terms of cost and in terms of time, and also maybe in terms of the tribunals or the mediators, the neutral parties' understanding of the dispute. However, we also have looked at some of its disadvantages, like the tribunal can be influenced by what the parties talked about, or what the party submitted during the mediation process, or maybe the party will even try to take the mediations as another chance to argue on the merit of their cases. On the other hand, we have the ArBMed app, and ArBMed app can be useful in the sense that there is a separation between the two proceedings, so we can actually maintain impartiality and also objectivity, and in a way it will increase the reliability of the process, will increase the enforceability of the result. However, from a Vietnamese point of view, from a culture point of view, I do understand that when Vietnamese business parties, commercial parties look to the idea of mediations or arbitrations, or they tend to think that they want to have someone to help them in making decisions, and not just simply facilitate them or creating a bridge. Sometimes they really want a third party to make an evaluation or to make an adjudication for them.
Yeah. Thank you very much, Mr. Ming. I think it's quite clear now that we are looking to the future of something more civilized with the separation of the arbitrator and mediator. Now, I would like to turn to Mr. Christopher To, who is the only common law-based lawyer and mediator and arbitrator in our panel, to make your own comments on what we have discussed on the different approaches, and also to share the current practice in your jurisdiction, I understand, in Hong Kong. Can you turn on your mic? Thank you.
Okay, good now. Okay. Now, I know that basically meetup is a relatively familiar practice in civil law jurisdictions. You mentioned early on, quite a lot of the speakers, that judges, arbitrators are used to taking on the role of mediator, encourage settlement between parties during the proceedings. However, being the only common law lawyer on the panel, I can say that with in terms of a positive note, that common law jurisdictions don't really take mediation with arbitration greatly. They always have a suspicion. When you're acting as an arbitrator, then move into mediator, then moving back to an arbitration. I'll come to in a minute the reasons why. Now, you quite rightly said that there was a Court of Appeal case in Hong Kong called the Gao Haiyan case. Our case basically set the scene in terms of moving forward with the meet-up scenario. Most people talk about meet-up. We could talk about mediation arbitration, or arbitration mediation, or arbitration mediation arbitration, or mediation arbitration mediation. So there's various variations. Now, the key thing about this whole thing about mediation is, from the common law perspective, there are two methods of doing mediation. One method is called the facilitative approach. What do you mean by that? The facilitative approach is whereby the mediator helps the parties to facilitate, to bring information from one party to the other, and he does not or she does not give any advice whatsoever. So that's one way. Another way of doing it is called the evaluative approach. Evaluative approach is whereby one party will ask, what do you think if this case goes to court? What is your views on it? Now, there has to be some balances or guidelines in place. If you give an advice, the other side's not going to like it. So the chances are the whole thing about mediation is about trust. The key thing is you have to do the evaluative in a way that you will not offend one of the parties. Now, as you quite rightly said, that in terms of advantages of mediation and meet-up, okay, Hong Kong does have legislation in place to allow for an arbitrator to subsequently act as a mediator, provided all parties agree in writing. Now, that is basically Section 33 of our arbitration ordinance. Now, the good thing about meet-up is the person who's acting as arbitrator is going to be familiar with the process, and he's actually going to focus on those issues whereby the parties might feel, for example, they're going to actually come to a conclusion or a settlement. In a way, it facilitates, how should I say, in terms of settlement. And also, most people talk about arbitration. They talk about arbitration in the sense that it takes years for an arbitration decision to be rendered, whereas they want decisions to be rendered much more quickly. This is whereby the meet-up approach could assist, for example, in early settlement. Another one is, all the speakers mentioned, is about this settlement. This settlement can actually achieve support from the jurisdictions of the courts, whereby you can convert that into what we call a consent award in arbitration, so it can be enforced in the New York Convention. So in a way, you can see that the benefits of mediation are there in terms of combining arbitration. Now, disadvantages, as you quite rightly said, problem with the common law jurisdictions is whatever is discussed in mediation, when you go back to arbitration, you as an arbitrator have a duty, if you're wearing the same hat, mediation and then arbitration, you have a duty to disclose whatever information was discussed during the private session, the joint session, in terms of arbitration. Now, if you don't do that, that could be problematic. So in the sense that if in our law in Hong Kong, under Section 33, we do have provisions whereby it says very clearly that whatever was discussed in the mediation, if the mediation was not successful and you go back to arbitration, then you must forewarn the parties that all information will be disclosed in arbitration. So you can see that why do people are skeptical about mediation and combining it with arbitration is simply because what happens if mediation doesn't settle, then you go back into arbitration. That's one thing. Another thing is, very important, is parties are reluctant because of this sometimes to even open up or discuss issues in the mediation to achieve that settlement. So the zone of possible agreement between the parties is going to be wider apart rather than closer together. So the chances are, if this hurdle can be overcome, I can assure you that more common law lawyers will be more sort of welcoming this process of meetup. But as it stands now, it's going to be very difficult because they believe that information disclosed in mediation could be used in arbitration to their disadvantage. So I hopefully I've given you some overviews from a common law perspective.
Thank you, Mr. Christopher. I think there was a case in 2018 from New South Wales court called Cooling Kai Council and Incos Construction Private Limited. This case represents a precise problem of the met up with the same person. If possible, you can share a little bit about this problem, and it has been highlighted by a number of law firms after that case. It was involved, I think, the problem between the problem of the same mediator and arbitrator, which is not allowed under the law of New South Wales. Is that correct?
I think it is allowed. The key thing is, for example, the issue about how do you have the protocols in place to protect information disclosed in the mediation, and how would it be used in the arbitration? I think that's the key. And I think if we can have some protocols, either some organization develop it so that, for example, this can be preserved, that the chances of using meetup going forward would be beneficial to the parties at hand. And I've done one case involving meetup whereby I was the arbitrator, then I moved into mediation, and I settled in the mediation, and I converted that into an arbitration award, consent award recently. And I can tell you that parties were very helpful because they believe that it cut down the process. And I think it's all about trust. The parties trust you enough to actually for you to actually do a good job in mediation. And if you're not doing a good job in mediation, you go back to arbitration, that could be problematic.
I see. Yeah, thank you very much for very insightful sharing. I think we cover already the very big question of whether or not the mediator and the arbitrator should be one person or should be two different, as Mr. Ming mentioned, to be a separation of these two people. I would like to raise another question to Mr. Tezuka Hiroyuki regarding the international cross-border disputes. Do you think these cross-border disputes have the different perspective that will require some amendment or adjustment of the existing met-up or up-met-up, which can improve the current practice or the existing mechanism?
Yes, the starting point is that in the international disputes, it is often the case that parties have different cultural legal backgrounds. So the way which would work in your own jurisdiction for the domestic cases may not necessarily work. And where one of the parties is from a common law jurisdiction, I would not expect that the idea to have the same person act as a mediator is acceptable to the other party. But having the different mediator has the problem of need of catch up and lack of feedback. The first one is that you need to have the mediator study a lot about the cases, particularly where there have been some exchanges of submissions and document production, etc. then it's very big amount of work. And interestingly enough, when I had one interesting made-up conference in the United States, a in-house counsel from a very large U.S. company said that in his experience, any attempt for mediation during the course of arbitration or litigation is likely to fail unless the proceeding comes to the stage of completion of the document discovery. So the idea is that without knowing what kind of evidence document is there, they cannot evaluate the case, and therefore it is very difficult to make an agreed settlement. And maybe Japanese parties won't have the same view. The mediation and settlement is useful, mostly because by doing so, you can avoid the very burdensome, costly document production or discovery. So the expectation is really different. And the lack of feedback, that is another problem of the different person as a mediator, is that even if one party behaves very badly and incooperatively, the arbitrator, when the case is returned to arbitration, may not have any idea as to which party behaved badly to break the deal, even though the parties come to a close. So in the 2014 amendment to the JCA rules, where they introduced the made-up, made-up, I was a member of the Rules Revision Committee, and I made a proposal, a kind of suggestion, to introduce, upon parties' agreement, consent, that the mediator, when failed to settle, may provide some feedback to the arbitrator, particularly in terms of the cost allocation. The idea is that if mediator makes a reasonable settlement offer, and one party is very reasonable, but the other party behaves very badly, and it makes the mediation process very useless. That's something like a sealed offer for the English court proceedings or some other proceedings, when the arbitrator makes the decision of the merit, but only at the stage of the allocation of cost, he or she can open the envelope and see what was the mediator's proposal. And then it may be possible for the arbitrator to somehow punish the bad cop, which may make the incentive for the parties to behave nicely. And that kind of a proposal was not supported by any other member of the revision committee, so that is not in the current rules. But I think in more and more cases, like ICC, people come to think about the use of a sealed offer so as to somehow assist the settlement. Thank you.
Yeah, thank you very much. Which is your suggestion is a brilliant idea, I think, in the context of the traditional arbitration. And we all, arbitrators, we all learned that the sealed offer in arbitration is a very powerful tool that actually drag the parties toward settlement. And if the mediator can do this function, it's really a good offer to the parties. I think before we continue, I need to inform that we have quite a number of great number of questions from the audience. I think it's better for us to just open the forum for all the audience to raise the questions, and it will go back to our key points that we touched. We have a question from the audience from Mr. Cao Kian Zhu, and he wants to make the questions live. So Mr. Zhu, can you please raise your question to the panel?
Hi, thank you, Mr. Tony. Can you hear me well?
Yes, we all can hear you. Yeah, please go ahead.
Hi, Mr. Tony. Hi, panel. I just have one question actually related to Mr. Tony's section just now. So I participated in an arbitration case in VIAC 2 years ago, and there was actually mediation done by the tribunal. So I'm just, if you can please kindly explain to me why we need mediation in the mechanism that Mr. Tony presented just now. Specifically, I'm just wondering if it makes my case more costly, more expensive, or if under the VIAC's rule of arbitration, can we still have free mediation by the tribunal? Thank you.
Thank you very much for the question. I want to answer this, but as a moderator, I would pass this on to Mr. Dat to answer. He is the right person to answer your question. Please, Mr. Dat.
Oh, that's great. Thank you.
Yes, thank you, Tony. I long for that. Well, when we discussed about the idea of making the new protocol, we were asked the same question from many users. So in Vietnam, there exists already the mediation within arbitration. So we must see, analyze the difference between the benefits, advantages, and disadvantages of different types. First, when you have the mediation within arbitration, not this protocol, you understand that it goes all the way from the request for arbitration and the statement of defense, also the counterclaim, and many submissions, exchange of opinion, hearings after hearing, and finally, fortunately, you've got a kind of settlement result. Well, it's like an award, but it's a kind of amicable award, a consent award. So for the parties, you can imagine that you do not save cost and time, and also you risk the result of no settlement agreement. You risk the result of final award, right? So in this case, the mediation within arbitration itself is just a possibility of the arbitration process. At our VIC, the statistics show that around 8% of the final result of the arbitral proceeding ends with mediation by a kind of decision by the arbitral tribunal. Now back to the protocol. When you start the arbitration, only the claimant just send the request for arbitration with the expectation that the other party agrees to take the offer to mediate. Again, let me answer the question: why the claimant need to send the request for arbitration? Why not take the mediation alone? Well, the problem is sometimes the claimant concerns about the statute of limitation. The other case, whereas the parties concerns about the final enforceability of the final result, because if it's international, right? You may need it as an arbitral award to invoke New York Convention. So back to the protocol. When you send the request for arbitration with the desire to take the protocol to mediate, then both parties are at the stage of friendly, just no rival at all. You do not submit much documents, criticism, and requests, and defend very few. And then luckily the mediation process at the protocol starts, and there's a good chance, opportunity, possibility that your dispute results in mediation. In mediation here at the mediation phase of the protocol, the point is that we expect that when you got your dispute mediated, it's by the mediator. By the way, let me emphasize that from our protocol, mediators are separate people from the tribunal arbitrator. We do not expect that they are the same. So to answer your question, it's like that. So it's again back to your efficiency, time and cost, and also relationship. You've got your case mediated fast and at low cost. And as I explained before, you'll be returned a kind of 30% of your arbitration costs. Yes, that's the point. It's a little bit technically, but in general, it's for the parties, themselves, business themselves, they see the efficiency to select.
Yeah.
May I also add a point to what Anh.
Yeah, please, Mr. Minh.
I think it's not just about cost. You also have to consider the situations when you cannot get a mediated settlement agreement and you have to go back to arbitrations. And then if you have the model in which the arbitrator and the mediator are the same persons, then there will be quite some risk to your final award. Because we have been talking about how the party submissions or party opinions in the mediations can influence the arbitrator, but we have not talked about how the arbitrator mediator's own opinion or own suggestions to the parties can be adopted by one of the parties when they are back to arbitrations. And when there is an award, one of the parties may want to challenge the award based on bias or impartial or lack of impartiality or whatever ground they can think of. And one of the grounds they will say is that maybe okay, the winning parties actually use the arbitrators or the mediator's idea in his subsequent submissions. And I think that is why the protocol can help you in such a complex cases.
Yeah, thank you, Mr. Minh. I think that's what exactly happened in the case of Cao Hai Yen that Christopher also mentioned previously. There is always a risk where you put the same hat on the mediator and arbitrator. And for your information, I think what I have collected, correct me if I'm wrong, Mr. Tezuka, is that in JCAA between 1999 2008, there has been 25 cases solved by mediation in the mediation arbitration, and also in CETAC about 30% of the cases are solved by MEDAP. But the main difference that VIAC and VMC are trying to introduce is that we have a team of the mediators who are totally different rank from the arbitrators. Their main practice is mediation, and they are trained and learn to and practice to be facilitative mediators. So they will not have the same characteristics as arbitrators, and they do not evaluate or give opinions. So we are moving forward to the orientation of being more facilitative. I think Mr. Zhu, are you happy with the answers from Mr. Dat and Mr. Minh?
Yes, thank you, Mr. Minh and panel. Following that, I just have one more tiny question on the ARP-MEDAP mechanics. So I'm just wondering if there is anything that we as participants in such mechanics should be paying attention to with respect to documents and evidence. So like for example, previously when there's mediation during arbitration, documents and evidences was submitted to the arbitration tribunal. But with the ARP mechanics, because I understand now that the mediation part is now separated from the arbitration part. So with respect to the submission of evidences and documents, is there any things that we should be paying special attention to?
You asked me.
Let me start that answer.
Well, this is a kind of a technical piece of advice, which is when you plan to take the protocol as the party, disputing party, especially the claimant, you just make it as short as possible, very, very few documents, just brief description of the case, your rights, your desire, your request, things like that. Do not submit from the first start a bundle of documents. When you make that, you write that in your request for arbitration. The other party, when they read your request, they understand your goodwill, a kind of mediation trend. So they may accept your request, accept the protocol. The protocol here only take place and take effect when the two parties agrees to, right? So when you submit the request for arbitration, include with as short as few documents as possible. That's my comment on that.
Thank you, Mr. Dat. I hope the answer is satisfactory. We move on to, thank you very much. We move on to a question on FIDIC clause, Article 20 and Article 21. It set out many tiers and steps to be completed before the arbitration clause could be triggered. And in many countries, those pre-arbitration steps are deemed compulsory. If I put a met-up clause in my contract, is mediation compulsory, conducted to go to arbitration? Can I address this first to Mr. Christopher?
It really depends. For example, mediation, we always talk about is consensual. Even if you put a mediation clause into your contract, one party can turn around and say that I've mediated and I don't think, for example, there's any settlement, so we're now moving on to arbitration. So it's the wording, how you draft the clause, the mandatory provisions there and so forth. Parties must attempt mediation, and the mediation must take place within a certain period of time and all that stuff. But as we said, mediation is consensual. A party can just turn up for mediation and sit there and not do anything. So the chances are that is another problem. So I think if parties are sincerely committed to reducing the cost of their case, and also to ensure that their case are handled in a timely manner, the chances are they have to be committed. If they're committed, the chances are they will try mediation. If it doesn't work, then they move into arbitration. Hopefully the arbitrator will decide the matter. So my short question to that is, it really depends on the drafting of the provisions. And also, second point, what about the parties' commitments towards using meet-up to resolve the differences?
Yeah, thank you very much. I think the question maker, it's an anonymous attendee, so I don't know the name. But if you may also refer to the case that I mentioned from the very beginning, the case of Hartronics Corporation and EPI in 2017, you will see that in some cases, if you put forward an ARPMET clause or multi-tiered clause, as you mentioned in the FIDIC, it might means that you will lose the arbitration clause in all if you don't if you are not able to proceed with mediation first. But the answer may vary, as Christopher rightly pointed out. It depends on the wording precise wording of the clause. The other question is actually on VIAC. As far as I know, the combination of arbitration and mediation is not new. This combination also exists in VIAC arbitration process and court litigation procedure. So what is the difference between the existing procedure and the new facilitative and mediation arbitration procedures that the speakers have mentioned? Maybe I would ask Mr. Ming to make a comment first, because I understand that you may be familiar with the court litigation procedure and the mediation in that context.
I think these questions we have touched on a little bit during the beginning of the webinar, and I would say that the old model, the one that you will find in the LCA and in the VIC rules at the moment, I think it is quite different from the ARP model that it's envisaged by the protocol. And the main difference is that in the old model, the arbitrator and the mediator, they actually are the same persons. They can be the same persons. And as in court proceedings, under the CPC, at the moment, we do not have the law on court annexed mediation yet. So I just comment on the current civil procedure code. So under the current civil procedure code, the judge will act as a mediator, and he will try to get the party to settle the case prior to the hearing. So in that sense, the protocol is very different, because you file the request for arbitrations, then the mediations will be commenced, and that they are two separate proceedings, and they are conducted by, on the one hand, the tribunal, and on the other hand, the mediator. And during the mediation process, the arbitrations will be temporarily stayed so that the parties can have time to mediate the dispute. And only if they cannot reach a mediated settlement agreement, then the arbitrations will resume so that the tribunal can decide on the issue. And even if the party can reach a mediated settlement agreement, then they can still come back to the arbitrator if they like, so that they can have the mediated settlement agreement converted into a decisions of the tribunal, so that they can enforce it, like under the New York Conventions, when they need enforcement out of Vietnam.
Thank you, Mr. Ming.
May I add just about the
yeah, please, Mr. Dat.
Add that, well, you see that in litigation, the judge do mediation, but they are not mediators. The same for arbitral process. The tribunal does mediation, but they are not mediators. Only in mediation process, there exist mediators. So there are three different professionals. Even for arbitrators, they may sometimes be mediators, but when they start the job as mediator, they wear on the court the role and the status of mediator, and all the skills, behaviors, and all other things, regardless of the law, they behave like that. And for the efficiency of the different methods of dispute resolution is different. So may I just add to Ming's opinion about that differently. So you must take advantage of truly mediation, right? Not mediation or mediation within litigation. Right? If you are the businessman, you have all the buffet, you have all the choices for you to select either one or two, right? Which suits you most.
Yeah. Thank you, Mr. Dat and Mr. Ming. Sorry for being a little bit critical, but I'm now looking at the law on mediation at court, and actually they have something quite similar to what you are doing in VIC and VMC. If a case is referred, this law is quite new. It's in June 2020. Under this law, the court has a side mediation center. And if you bring any case to court, firstly, the court will bring the case to the mediation center, and they have the mediators next to the court, but not like the original traditional way. But this mediation center within the court will do the mediation, and it will be done by some ex-judge who are now become mediator. And then if the case is not successfully mediated, then it will be brought back to the litigation procedure. And is that a competition to the arbitration world? Mr. Dat?
You are one of the lawyers who asked us question repeatedly. May I have a short answer that, well, you see the law is quite thick like this. The decree 22 2017 for commercial mediation is very short, some 44 articles. And Article 14 is all about the procedures, all about the procedure for mediators to mediate the case. So from a kind of expert view, may I say that for businesses, again, you select mediation, you need to read all the procedure. The procedure allows you to select mediators, and procedure for the mediators to act as a true mediator. You will see the difference between that in the decree 22 for commercial mediation and the law for a kind of mediation, court annexed mediation. Yes. So that's, oh, may I ask Mr. Minh to add, because you are the counsel, you may have a more insight into
Yes, I think as a business person, they may also want to, the client may also want to think about whether they want to have another commercial persons to help them to resolve their dispute, or if they want an ex-judge or an ex-government official to mediate the dispute. And I think that's one of the very, very, very important considerations that the business party should ask themselves when choosing between court annexed mediations or commercial mediations as being done by the VMC.
Yeah, thank you, Mr. Minh and Mr. Dat. Actually, your short answer is very strong to us. We really do consider between court litigation in general and mediation and arbitration as a different world. So it's quite obvious and clear now. The next question is related to both Mr. Christopher and Mr. Minh. The question is, I was advised by a Singaporean counsel that I should use the mediation arbitration clause in my transaction, which is an IP transaction. And I was told that if the mediation goes well, then we will file a request to SIAC to have the mediated results being converted into a consent award. A Vietnamese lawyer advised me differently, that if the parties reach mediated settlement, there are no longer disputes between the parties, and an arbitration proceeding hence could not commence. Could you give your own comment on this two different versions of advice? Mr. Christopher, please. Can you turn on the mic? Thank you.
Now, one of the examples I'm going to give you is, if you look at the 2018 HKIAC administered arbitration rules. Now, there's three ways of actually rendering an arbitration award, or even an order. One of them is termination. Say, for example, if the both parties do not respond whatsoever about mediation or arbitration, and so forth, then you can actually issue an order for termination. Another way of doing it is both parties have agreed to basically settle the differences, you can convert that into an arbitration award, and we call that a consent award. So the HKIAC arbitration rules allow for this. Now, but the key thing here is very important is the parties have to agree in writing. They basically have come to a consensus that they want to actually put this into an arbitration award. That's very clear. So the key things, that's the key thing. Now, the gentleman who said basically there's no dispute. At the end of the day, if the rules of that institution allow you to do so, okay, the chances are that will alleviate the problem. Okay? In terms of, for example, there is no dispute, but in this situation, the HKIAC rules, as well as CET rules, do allow you to actually convert that agreement by parties into a consent award by the arbitral tribunal, provided the arbitral tribunal is still in operation. Okay? What happens in some situations whereby all parties say, okay, we don't need you, Mr. Arbitrator, so he's finished, and parties go away and negotiate, and they come to a settlement, and they come back to the arbitrator and say to the arbitrator, please convert this into an arbitration award, and the arbitrator says, but you've told me to finish the case, so I finished, my job is finished, so if you want me to do it, you have to reconstitute me again. So that could be a problem as well. So I think the key thing here is very important is if you're thinking of settling, you can do so, but make sure the arbitration tribunal is still in operation. And if you can't settle, then you go back and tell the arbitrator. If you do settle, you can tell him to convert that into an arbitration award by consent. Does that answer the question of that gentleman?
Yeah, I think maybe Mr. Ming wants to add some points.
Yes, I agree with Mr. To that we have to look at the SIAC rules and Singapore law first to see if that is possible. And we do have to also see that there's an advantage in doing so in this case. So because if you have a mediated settlement agreement converted into a consent award, then there will very likely you will be able to take advantage of the New York conventions when it comes to enforcing the settlement agreement in the form of an award.
Yeah, thank you, Mr. Ming. I think we have sufficient time to answer like 2 more questions. One question actually addressed to Mr. Hiroyuki. Have Japanese courts ever addressed the question of whether a settlement agreement converted into an arbitral award before the commencement of arbitration proceedings is enforceable under the New York Convention?
Yeah, I'm afraid. I'm not aware of any such issue. And in reality, if that issue is raised, the enforceability issue is raised in the context of arbitral consent award made in Japan. There is no New York Convention issue because it's a domestic award and it's enforceable under the Japanese domestic law. So when you talk about the Japanese court's attitude in terms of the applicability of the New York Convention, that means that the award is made outside of Japan and enforcement is sought in Japan. Yeah. So I've never seen that case. But my thinking is that if the consent award reflects the legally binding agreement, which has a sufficient specificity, then maybe it's likely that the Japanese court will consider it enforceable. And in reality, if you look at the Japanese arbitration law, regardless of whether the foreign award is a New York Convention award or a non-New York Convention award, the same rule applies now. So it's probably not the New York Convention issue, but it's more like the ancestral model laws requirements for enforceability of award. And that if the consent award includes something which is not based upon the legal rights and obligation types of analysis, but rather a fairly business-oriented commitment, it might not be enforceable per se.
Yeah. Thank you, Mr. Hiroki. I think there's one question left.
Can I maybe also to show,
yes. Please,
show, for example, two areas. Can I maybe share the screen to show you?
Yes, please, Mr. Christopher To.
I'll share. Can you see this? This is basically the arbitration law of Hong Kong.
Yes,
now,
we see it.
It says here, Article 30 of the Untitled Model Law. So this is Section 66 of the Hong Kong law, which we've adopted the Untitled Model Law. It says here, number 2, an award on agreed terms shall be made in accordance with the provisions of Article 31 and shall state that it is an award. Such an award has the same status and effect as any other award on the merits of the case. So that's very clear in terms of, for example, the question about, for example, whether a settlement agreement could be enforced as an arbitral award. I hope that's clear.
Yeah, thank you very much, Mr. Christopher To. I think the answer has cleared. And the one question left for us to answer is, I have come across dispute settlement clauses which stated that in case there was a dispute, parties must resolve through mediation first before resorting to other methods, which is quite popular in construction disputes. Will the combination of ARP-MED-ARP lead to a longer settlement period? Because not all disputes can be mediated. And also, what is the effect of the combination in case the parties want to go to court and do not want to mediate? So if there has been a clause and the parties later on, one of the parties don't want to mediate, will that make the whole proceeding longer? I will address this to Mr. Nat.
Well, thank you. May I just address it back to Tony for answering that question. But before that, let me add something to Vietnam. You know that Vietnam is not yet a member state to the Singapore Convention, right? So we talk about mediation and talk about ARP-MED-ARP protocol. Internationally, if you have an international mediation in Vietnam, well, we are not a member to the Singapore Convention. Then it breaks the enforceability internationally. So we suggest you take the protocol advantage and request the tribunal to revert your settlement agreement in the mediation phase into the consent award. So that you may have you may invoke the New York Convention. We have here in the panelists, we have Mr. Christopher To and Mr. Tezuka. They are 2 of the 13 international mediators of VMC. So if a foreign party and an FDI party in Vietnam, you have a dispute, you may select one of the 2 or the other of the 13 international mediator of VMC, and you can take the protocol here. So back again, why I address or I turn the question back to Tony, because I heard Tony talk a lot with anger about the fact that the parties do not respect the agreement, the multi-tier agreement, first to mediate or even first to negotiate, then mediate, and then arbitrate. So the punishment in Vietnam, the punishment in common law countries, something like that. Tony, could you please share your expertise on that? Thank you.
I think I cannot talk about common law to overwhelm Christopher Toh. He's a better person to talk about the issues with the punishment. Maybe if you don't mediate or you fail to accept an offer to mediate before you go to court. So I think generally from, for example, English law perspective, you will normally be punished by the court for cost in the way of cost for a word. And also it will be in terms of instead of reasonable cost to be recovered, it could be in the form of indemnity. So it's the basic rule, and that will enforce or encourage the parties to do mediation and accept the offer for mediation. Christopher, would you like to share your views from the Hong Kong perspective?
I think that you're right, because Hong Kong follows like England, Australia, and also Canada and all these jurisdictions. And these jurisdictions under the civil justice reforms do call for sort of actively promoting mediation and use of mediation. In Hong Kong, the same. I think Singapore, Malaysia, the same. And if you do not, as you quite rightly said, if you do not proceed into mediation, there could be cost sanctions against you. In terms of, even though you win the case, you might not be able to claim all your costs because you have wasted a lot of time and cost when this matter could have used mediation to resolve it from day one. So there are quite a few cases in England, quite a few cases in Hong Kong, whereby the judges have actually said that I'm not going to give your cost back because you did not basically honor a principle of engaging in actively participating in mediation.
Thank you, Christopher. And I think there's a good reason for that. The success rates of mediation before you actually find yourself in the end of arbitration proceeding is about 70 to 80%. So it will save a cost, a lot of cost for the parties before they have to go to the end of the proceedings. I think we don't have more time.
Yeah, just to supplement, the Hong Kong Polytechnic University did a survey about family mediation in Hong Kong, and they found that 78% of those who go through family mediation settle.
That's great. So we have a very precise percentage figures provided by Mr. Christopher Toh. For that, I think it's really happy ending. I don't have more questions to ask from the audience. And I again thank you all the panelists for their participation. And I'm really glad to moderate this session with all the learned colleges from Hong Kong, from Japan. I will pass this back to the organizers. Mr. Hang from VIAC.
Well, on behalf of VIAC and VMC, we would like to thank you, Tony, the moderator, Mr. Christopher Toh, Mr. Tezuka, VMC mediator, and Mr. Ming, a very close friend of VIAC and VMC. We thank you, the participants, for attending this webinar by VIAC. We plan to organize further. We hope that you have answered our survey with giving us the opinions for the following topics and as well as other things. So thank you very much and wishing you a very nice weekend ahead. Thank you. See you very soon. Thank you.
Thank you.
We are conducting the survey, so we would appreciate it if you could spend some minutes to fill in the survey for us to serve you better in the future. Thank you. The organizer just informs us that
Thank you, Christopher.
we are having several other webinars. The very next one would be on the 30th October, which is on something online, all the techniques on the technology, the online mediation, online arbitration, everything, right? So if you, well, we think it would be a very interesting topic under the status of COVID-19, where you may be restricted from traveling and also video conferencing and teleconferencing. We do have a kind of platform for mediation, and we are thinking of another platform for arbitration. So we will show you part of that next seminar, 30th October. See you very soon. Thank you.
Thank you.
Okay, thank you. I'm like an advertiser. Thank you. Wishing you a very nice weekend ahead. Thank you. Thank you. Goodbye.
Thank you. Thank you very much.
Thank you.